Welcome to Canadian Justice. I'm K.R. Davidson. Today we are talking about Parliament's attempt to mandate sexual assault and social context training on Canadian judges. Bill C-3, which is currently before the Senate, is premised upon a bill formally introduced by former Conservative leader Rona Ambrose, after some high-profile rulings in sexual assault cases revealed perplexing behavior from the bench. While some are applauding the government's reintroduction of the bill, others are questioning the infringement on judicial independence and a slippery slope of Parliament seeking to influence how judicial decisions are made. With me to discuss this is Senator Mobina Jaffer, Chair of the Legal and Constitutional Affairs, and Senator Pierre Dalphon, a member of that same committee. Thank you so much for joining us on the show today. Senator Jaffer, if you can just give us an understanding of how this bill originally came into being. It's my understanding that Rona Ambrose was the initial sponsor in the House of this bill. If you can give the Canadians a bit of a background on this, that would be great.
Yeah, so it started off with a case by Judge Camp in Alberta. And I think that's Rona Ambrose was very, very upset with how he treated the victim in the case, where he made some very inappropriate comments of what she could have done so that she would not have got assaulted. Mm-hmm. And so then she started the implementing this bill, or she started the introduction of this bill, and a very honorable thing to do to raise awareness of sexual assault across Canada. And so that was a very good step that she took to let Canadians know that even judges are not immune. Even they cannot get away with making inappropriate comments about women when they're victims of sexual assault.
Sure, and it's my understanding that you've been involved in your previous career, prior to being a senator, in judicial training, and is sexual assault training been part of that training before?
Yeah, I've been a lawyer for many years, for over 40 years, and from a very young age, I worked on issues of sexual assault, violence against women, and racism training with judges, with the Judicial Council, or with immigrant women. We did a number of trainings with the judges. And when I first started, there wasn't an organized way, or like Judicial Council was not that organized, and there wasn't the kind of training that when I started. But now it's the best training place in the world. And so we're in a different era now. But I also was on the Canadian panel on violence against women and chair of violence against women in the province. So I've been involved in sexual assault issues for many years.
And so Senator Dalphon, of course, you have a background with the Quebec Court of Appeal, and you are a judge. How did you get involved in this bill in the first instance?
Well, I was also a trial judge. I was a judge for 20 years. So, and I was very involved in the activities of the Canadian Judicial Council. I was involved in I was chair and president of the Canadian Superior Court Judges Association. So it represents all the federally appointed judges. So these are issues that came before me, either as a judge, a sitting judge, or through as a representative of the judiciary. So I've had many cases that were appealed where there was some mistakes done by judges in the previous instances that were showing some lack of understanding, not only of the legal rules, because sometimes the rules have been changed so often and they were complex, and I can understand mistakes are possible, but there was a kind of lack of understanding of all the rules. But what was more disconcerting to me is the fact that also some of the judgments were showing bias and prejudice and analysis through lenses that are not neutral lenses, but lenses that are biased because of your own background, your own education, your own many things, myths and stereotypes that we carry in each of us. And so these are kind of difficult issues, and therefore only training can help somebody to put himself or herself in guard against prejudice and bias that are most of the time unconscious.
Okay, and of course, here at the heart of this issue was Judge Camp's ruling, which was, I would say, it was an atypical ruling from what I've seen. So I'm going to, we're going to go to the commercial messages, and then we'll talk about how the Senate has been dealing with this bill once it moved up in the House in the last instance. Stay with us. We'll be back after these messages. Welcome back to Canadian Justice. We're here with our senators from the Legal and Constitutional Affairs Committee. It's considering Bill C-3, which is a bill which is seeking to impose training on judges on sexual assault. So, Senator Dalphon, it's my understanding that you're the sponsor of this bill. How did you originally become involved with this bill?
Well, it's a funny thing. I think it's Mrs. Ambrose was complaining about the fact that the Senate was not dealing fast enough with the bill at the time. And in an interview on CBC, she criticized Senator Joyal and myself for holding up the bill. Okay. And I was a new senator at the time, and of course, I was not solely aware of the background of the bill, but I certainly picked up my curiosity and I got involved. And I called her and I said, Mrs. Ambrose, I'm very, very in support of the idea of having more training for judges on these issues, and I support the intent of your bill, but I'm concerned about some disconcerting aspects of it, which I think are encroaching on judicial independence. And are you willing to engage in some discussions to see how we could make it more respectful of all the principles at stake? And she, of course, was very open-minded. And we worked together with Senator Pratt and Senator Andreshchuk, that was at the time the sponsor of the bill. And we came up with substantive amendments that were accepted unanimously by the legal committee of the Senate at the time. But unfortunately, the election was called and the bill died on the other paper.
Okay. And so, Senator Jaffer, what were some of the changes that were addressed in the Senate in the last instance?
Well, some of the changes were like the training of the judges. When should the training happen? That was one. And then who should do the training? And, Senator Dalphon was very intimately involved in that. And I would like, I prefer he spoke about it because it'd be only fair because he was the one who spoke to the different sides and made some very good amendments. But basically what it was just it wasn't a fair bill when it came to looking at the judiciary. And I would ask Senator Dalphon if exactly the changes, because he was very instrumental, so I don't want to speak for him.
No, absolutely. And to speak about this specifically, because I think the concerns of some of the committee were any encroachments that Parliament would have on the judiciary, and obviously this is a constitutional issue. So, Senator Dalphon, what were some of the considerations that needed to be made in the amendments to the bill on some of the constitutional issues at play?
Thank you. The two really major concerns. Some were dealing with the candidates applying for judgeships were not workable, but I will go straight to the two constitutional problems. One was about the content of the courses the training that should be provided to the judges. The draft of the bill was making it compulsory for the Canadian Judicial Council or the National Judicial Institute is providing the training to not only decide about the content, but to have a content decided by outside groups, such as groups representing victims or other type of groups that were involved in sexual assaults. So this was going a bit, I understand the intent that there should be consultation, but the content of what is presented to judges in training should be left to judges. They should define what is the content, they should decide who should be invited, and they should decide to make sure that the presentation is always as neutral as possible. And it was always it's not a way to have kind of influence or lobbying on judges. It has to be proper judicial training. The other thing that was very challenging was the obligation for chief justices of each superior courts to report on how many cases were heard on a yearly basis by judges that have not received that training. So you had to report about how many cases were heard by judges that went through the training, and how many were heard by judges that didn't go to the training, like assuming that if you hadn't gone to the training, you were not competent to hear the cases. And I gave the example to the committee that if you have a former Crown attorney who is specializing in sexual offenses, who is appointed the Justice of the Superior Court of Quebec, that person will be reported but has not followed the training, would be reported in the list of those that have not received the training but nevertheless heard these cases. One probably was the most qualified person to hear the cases. So that will gave a kind of wrong message to the public. And I thought, otherwise, and on top of that, that was stepping in the courtrooms and the management of the courthouses.
Wow.
And that doesn't belong to the government.
Well, and that's interesting, because when we come back after these messages, we'll talk about the concept of judicial independence. Stay with us. We'll be right back. Welcome back to Canadian Justice. We're here with our senators on the Legal and Constitutional Affairs Committee that are reviewing Bill C-3, which is a bill seeking to impose mandatory training on judges on sexual assault. So, Senator Jaffer, right before we went to the break, Senator Delphine was talking about some of the amendments that were made in the last bill that was before the Senate on concerns specifically around judicial independence. And what are some of the concerns in the first instance on this issue of judicial independence? And in its current iteration, are you seeing that those concerns have been satisfied, or are those concerns still present?
Well, for me, they're even worse now.
Oh.
And my concern is that it's a real slippery slope when you have a bill like this. And, I want people to know that I'm someone that's always worked on issues of sexual assault. I'm not talking about the subject of sexual assault, but you can't start on the slippery slope of, now today we are going to mandate that the judges do sexual assault training. Now this new bill also has systemic racism and systemic discrimination, and has a phrase like social context. Now what's social context? And, I know we'll be talking about that later, but to me, it's a real slippery slope. And we have the best judiciary in the world. And we know that they have a very good training center. And I don't think that Parliament should go where it's going.
Okay, and to give the Canadians a bit of a background, the way our Constitution is specifically set out is that Parliament is distinct from the judiciary, and there's to be independence of these institutions, and there's not to be an encroachment on one or the other. And so I think that that's what one of your concerns is that you're referring to. Senator Delphine, of course, that must be a concern that you've been looking at. What is your position on the current state of the bill and the issue of judicial independence?
I certainly share the concern that is raised by Senator Jaffer, especially that was the case of the first draft of the Ambrose bill at the time. But this has been changed. The current bill provides for invites the Canadian Judicial Council to provide training on these matters. It's not compulsory. It's not mandatory. We're not telling what they should be doing. We're inviting them to do so. And I think it is justifiable for Parliament that each year allocates $30 million to the Canadian Judicial Council for its operations, including $6 million per year for judicial training, to say, well, by the way, use that money to do judicial training. We're giving you $6 million to judicial training. And here's some aspects that you should cover that we invite you to consider to cover when you do the judicial training. I think this is part of, there's no constitutional obligation for Parliament to vote money for the judicial councils to do training. This is public money being used, and maybe the Parliament has an interest in knowing to what purpose the money is used and to be informed about the use of the money.
So, Senator Delphine, are you saying that the training is not mandatory, but it's merely an invitation for the judiciary to inform Parliament on this, that it's not mandatory? Is that what you're saying?
Training is mandatory in a sense through the guidelines that were adopted by the Canadian Judicial Council, and that can be found in the Council's ethical principles for judges. And there it's made very clear that judges should guard themselves against stereotype, myths, or prejudice, that the judgment which is based on that is not an impartial judgment, that judges should design a plan to keep on training, and that they should be aware of all the aspects of judging, including social context. So this is what the judges are asked to do, and Parliament is supporting by providing the money and by also inviting the Council to make sure there are courses on certain specific topics that are of high interest for the populations, where the population is thinking, maybe wrongly, maybe rightly, but where some people are thinking that there is a lack of proper training in these matters. And the Parliament, like the courts, work together to achieve more trust in the system, because the courts are so critical to our democracy, and they rest on trust. And Canadians must trust the courts, and they must trust that the judges that are sitting there are properly trained and able to deal with sexual offenses cases, which are difficult cases.
I'm going to have to cut you off there because we're going to go to our messages, but I'll let you pick that up when we come back after these messages. Stay with us. Welcome back to Canadian Justice. We're here with our senators. They're reviewing Bill C-3, which is a mandatory sexual assault training for Canadian judges, and they're part of the Legal and Constitutional Affairs panel or committee in the Senate. So, Senator Jaffer, one of your comments that you had expressed some concern with is the concept of social context training, which is incorporated into this bill. Can you give us an understanding of what is social context training, and what are some of your concerns that you're expressing in this area?
And that's my challenge. What is context? What is social context training? I've had a Library of Parliament look at it. This is the first time it's been used in this legislation, in the series of legislation on Ron Ambrose's certain different bills. It's the first time it's been used. And the minister says it's to help better navigate the social and cultural factors that are likely to come across at any time for the bench. And so I would say to the minister and to other people that we should appoint judges who understand our communities. We should not appoint judges who don't know our communities. And if judges need to be taught social context, they should not be sitting on the bench. And what does social context mean? And how is Judicial Council going to know what do they do training on? It can be anything. I think it's very unfair on the Judicial Council and on the judges to say, now you're going to do training on social context. We say you will do training on social context. And then, as I said, it's a slippery slope. In this legislation, it started with sexual assault, and then it was social context, and now it's gone to systemic racism and systemic discrimination. And, all very valid topics, and all topics I have worked my life on, but this is not where Parliament should go. I have faith in the National Judicial Council and in the leadership of the judiciary, that they will make sure these courses are taught. We have moved a long way from when I first started practicing law. And I don't think that this is where Parliament should be going.
So, Senator Dolphin, what is your response to Senator Jaffer's position that social context training needs to be either defined much more succinctly or removed, in essence, so that we don't have this slippery slope of Parliament intruding upon the judiciary?
Well, I think that to avoid any interference with judicial independence, we should leave it as broad as possible. It would be up to the Canadian Judicial Council to define the extent of what social context means, and to make sure that all the proper training with cultural diversity and sensibility is provided. But I have great trust they will find out the way to provide the proper courses.
Wow, and that's an interesting conclusion to our commentary. Thanks so much for both of you for coming on, letting us have a little bit of a peek into the rigor of the discourse in the Senate on hearing this bill. Thanks so much. Today, we heard about Parliament's effort to correct the behavior of some judges who clearly lack the understanding to properly adjudicate sexual assault cases. We also heard how this has presented concerns for the independence of the judiciary and concerns with respect to the bill's ambiguous definition of what constitutes social context training. Madam Justice Susan Himmel, the president of the Canadian Superior Courts Judges Association, stated, "The principle of judicial independence requires that judges be unfettered in the independent and impartial exercise of their judgment. While there is a greater need for the advancement of reforms to ensure our courts serve to address the needs of sexual assault victims, we should be wary of allowing the good to compromise the structure of our institutions that allow for the very justice that we seek." What do you think? Should we allow for a compromise in allowing politicians to direct judges on how their decisions should be made? Or should those that govern our judges ensure that they do not exceed the constitutional limits? You be the judge. Let us know your thoughts on our social media platforms and exercise your ability to speak on issues important to Canadians. I'm K.R. Davidson. Thanks for watching Canadian Justice. And remember, keep examining and know that you are part of the solution.
I'm Nima Rajan, and this is the Forum Daily, a daily news program that brings you the biggest stories of the day, both domestic and international. The Forum Daily gives you the facts without the spin to help you stay informed in an ever-changing world. Join me weekdays for the Forum Daily, 6 p.m., 9 p.m., and 11 p.m. Eastern, right here on the News Forum.